Hello, I'm attorney Joseph Nivin, and I'm here to talk to you about getting an order of protection in family court. To get an order of protection, you will have to prove two things. The first is what is called subject matter jurisdiction. What that means that either you are related to the person that you're seeking an order of protection against by blood or marriage, or that you were in what's called an intimate relationship. Now, most people think of intimate relationships as being the same thing as sexual relationships. However, the law specifically says that the relationship does not have to be sexual in nature in order to qualify as an intimate relationship. However, it is not supposed to be what's called ordinary fraternization, which basically means just someone that you see around the bakery sometimes. If you can prove subject matter jurisdiction, then the next is to prove that the other person committed what's called a family offense, which is a list of crimes and violations that constitute a family offense. Now, there are two ways that you can have this case end. The first is what's called a settlement. So in many cases, the respondent, which is the person that you're seeking the order of protection against, will agree to an order of protection for a short amount of time, like let's say 6 months or 1 year, in order to reduce the risk on their end that they end up being the subject of a lengthier order of protection. What it also gives you is it relieves you from having to prove your case at trial. Now let's say that you don't settle, that the respondent does not agree to an order of protection of the nature that you're willing to accept. Then there will be what's called a trial, where we will have to prove, first of all, that there is subject matter jurisdiction, and secondly, that the respondent committed a family offense. So how do we do that? Almost definitely you will testify, meaning that I will ask you questions about what happened. If the respondent has an attorney, then the respondent's attorney will get to cross-examine you, meaning ask you questions. And then we go back and forth a little bit, and then we can call other witnesses. So for example, if somebody else witnessed the events, we can call them in. We'll ask them about what they saw, and the respondent's attorney will get to cross-examine them. We can also present what's called evidence, like text messages and photographs, to prove your case. So after we present our case, the respondent will then present their own, and the court will determine whether or not you proved what's called subject matter jurisdiction, and also that the respondent committed a family offense. So let's say that we win the trial. So what happens then? The court can do two things. The court can first of all issue an order of protection. Usually the lengthiest order of protection that you can get is 2 years. However, in the most severe cases, if there are what are called aggravating circumstances, then you could potentially get an order of protection for up to 5 years. The court can also what's called suspend judgment, meaning issue certain orders against the respondent for a period of up to 6 months. And if the respondent follows those orders, then the case is over. If the respondent does not, then we can come back and we can ask for an order of protection. Additionally, even though I've never seen this happen, the court can put the respondent on probation. When the order of protection expires, whether it be via settlement or after a trial, then you can come to court and ask for an extension. Of course, the judge can say yes, the judge can say no. Every case is different. So if you have any questions about your particular order of protection case, then you can call my office at the number on your screen. You can also visit my website at the address listed on your screen. Thank you very much, and I look forward to helping you out.